Okay, so taxes. So we got some law here. Now we open up with contract law. It sort of says about contract law, principles of contract law. It's not actually about contract law at all. It's about the English legal system. This so it sort of says that, and it says contract law in the syllabus, which would narrow it down significantly. But it's actually not. It's a lot of the English legal system in here. Fortunately, the questions aren't that hard. So identify whether the following statements are true relating to criminal or civil law. So criminal law deals with the state against individuals with the purposes of punishment. Punishment. In there, civil law is between sort of individuals with the purposes of restitution, not punishment. Punishment is an American approach when it comes to civil law, that they have things like punitive damages to punish the wrongdoer. We do not have punitive damages within the English legal system about civil law. English civil law is about returning people to the same point or to deliver fairness. And criminal law is about breaching criminal law, laws which are about breaching laws against society, essentially, and about punishment. So, cases are dealt with in the county court. Right, so this is the lower court, really, in here, the county court, and the lower court for criminal law is magistrates, and the lower court for civil law is county court. The burden of proof lies with the prosecution. Right, so there's a prosecution for a start, there, and the prosecution is in the criminal law. Okay? Within the civil law, the burden of proof, so within the criminal law, it's beyond reasonable doubt. Because you're going to put somebody, potentially put somebody in prison, or you're going to give them a criminal record. The burden of proof lies, beyond reasonable doubt, and therefore it relies with the prosecution to prove, guilt beyond reasonable doubt. Reasonable doubt, not 100%. But in a criminal case, the defendant does not have to prove anything. It's the prosecution that has to prove that things are beyond reasonable doubt. In a civil case, the burden of proof is only on the balance of probabilities. So both the claimant and the defender, so the defendant here. So prosecution versus claimant, and both of them are defendants. In terms of the defence, the burden of proof is on the balance of probabilities, so 50-50. Which side does it sort of land on, really? And so there is no burden of proof there between the claimant and the defendant in the civil law. So that's the answer for that one. Nice little opening between criminal and civil law. Pretty easy as well, that one. Identify with the following situation to create a binding contract. So to create a binding contract, we need to have offer. We have an offer, acceptance, really, and we also need consideration. So you and a friend each buy a lottery ticket, okay, and agree to equally share winnings if either win. Right. So do we have offer? You might agree it there, though. Do we have acceptance? Well, you've agreed it, but do we have consideration? And you don't really. You've just sort of agreed this sort of thing. You haven't each bought part of the lottery ticket, each of the other one's lottery ticket. So you haven't got a consideration there. So you've not got a contract. So that is more of a promise. And so just in terms of this idea of consideration, basically, is it something that you're actually giving something over for, something of material gain for each either party, material gain or material loss, or is it a question of just a bit of a promise? I could say to you, I promise you that I will, complete whatever book in the future. And you might go, I'm going to buy that book, but if I'm only just promising you, you haven't actually given me any money for it yet, whatever, then I'm not going to, you actually can't hold me to it, even though I'll complete them all in the fullness time. You are the last person to raise your hand during an auction before the auctioneer's hammer hits the table. So you have offer. You've made an offer. You've raised your hand. The auctioneer has accepted your offer by whacking the gavel down in there, and so that has created a binding contract. There is offer, and there is acceptance, and there is consideration. You send an email to confirm that you want to buy a car that you saw in your local garage. So has the local garage made an offer? They've put together a price, but this is what's known as an invitation to treat. What they've done is they've invited you to make an offer of acceptance, an offer to them, but they actually haven't accepted it. So this is where you have prices, let's say in a shop, and the prices are all out in the shelves. That's an invitation to treat. The actual offer and acceptance only happens at the till. So let's say that they got it wrong in the pricing. You put it through the till, and then it's, oh no, it's not that price, it was this price over here, which is a higher price. You can't go, haha, but you offered it and I've accepted it and therefore it's a contract. No, that's just an invitation to treat. And in the same way as here, the car price you saw in the local garage was an invitation to treat. It was not an offer. So in actual fact, what's happened in this email is that you have given an offer to buy the car for that. The garage now has to accept that offer in order for it to be a binding contract. Okay. You enter into a contract to buy goods, but the contract is breached. Ooh. This has caused you to lose money, and you would like to make a claim against the seller. Okay, that's fair enough. If a breach of contract foreseeably causes economic loss, so foreseeable economic loss, right? And that's the point, is if you have a foreseeable economic loss, then you can claim for that. Okay, damages will generally compensate for that loss. Yes, they will. So they will. So it has to be foreseeable. If it's a question that it wasn't foreseeable, so let's, and the way in which the case law this it's basically a washing machine isn't like installed, and as a consequence somebody loses out, a business loses out on their normal profit, but they got this really big offer, a big contract that was available, and they wanted to sue for the big contract as well, and they said no because that was a new thing and it wasn't foreseeable. In here, foreseeable economic loss. Damages will generally compensate for that loss. Yes, they will, provided that there aren't any limitations within the contract that limit losses. And typically, contracts include limitations for the loss of, they don't extend to profit, losses of profit. But if there's not one, that's not in that clause isn't in the contract, which it wouldn't be at AAT level 2. We can have compensation for the loss. But remember, foreseeable, not foreseeable. Not possible. If the contract states the amount of damage payable if the contract is breached, this will always be the amount paid. Now notice here, will always, we've got our little alert register going on here. Will always is not always. Now, if I remember back to the original part where I was saying the civil law in the English legal system is not designed to be punitive. It's not designed to reach penalties. So let's say you and I, make a contract, and I decide to put in this really high penalty in it, so that you perform the contract, and the intention of that penalty is to intimidate you to do that contract. Really, you must then do it because you'll make a huge loss otherwise. That's a punitive penalty clause, and it's not enforceable. I can only enforce penalty clauses, which is an amount of damage you'll pay if you breach the contract, that are equal to a loss that I can prove that has actually occurred. Now, one of the ones where you sort of tend to have that one is somebody who's tried to say, well, you can't sue me for parking illegally in your car park and charging me the sort of £85 of parking fee. And they said, well, actually, yeah, because that was all the cost it sort of took to sort of dissuade people from parking illegally, and writing the letters and doing all the various sort of cameras that we have to put in there, and the judge actually upheld the parking fee. So in this one, it's false, because it won't always be the amount paid, because it might be unfair. It actually has to be the amount of loss that is incurred. So that's the end of our law question, which is quite nice.